Good morning. I am Dr. Ritu Gupta, Faculty, National Law University, Delhi. In today's module, we'll discuss the provisions which are there in United States and European Union to regulate vertical agreements. Let us quickly have an overview of the contents of this module. This module primarily focuses on the current legal framework for vertical agreements as is there in the United States and European Union. More than a century old, the Sherman Act 1890 continues to regulate in United States along with the Federal Trade Commission FTC Act and Clayton's Act. In European Union, the vertical agreements fall within Article 81 subsection 1 of the EC Treaty. The antitrust provisions governing these agreements have undergone thorough reforms over last decade in both these jurisdictions. This is what we see. In United States, the Supreme Court has gradually placed vertical restraints out of the per se illegality rules, while in the European Union, Regulation 330/2010 has replaced Regulation 2790/99. However, public interest remains a touchstone to determine reasonableness of the restraints in such agreements. Yes, this is what we are going to discuss. How do we discuss this reasonableness? And similar terminologies have been adopted both in the United States as well as in European Union. To understand this module better, we need basic knowledge of antitrust legislations. And the objectives of this module are, the main objective is to discuss legal framework for vertical restraints in United States and European Union, to apprise the students of the latest developments on this issue, and to make students understand the judicial approaches towards vertical agreements in United States and European Union. Let us have a little introduction of the concept. Vertical agreements, as we had discussed in the previous module also, that these are the agreements between undertakings at different levels of the production or distribution chain and relate to the conditions under which the parties may purchase, sell or resell certain goods or services. For most vertical restraints, competition concerns can arise only if there is insufficient competition at one or more levels of trade, that is, if there is some degree of market power at the levels of the supplier or the buyer or at both of these levels. The provisions of the antitrust legislations both in US and EU prohibit such agreements if such agreements act as a clog on the free play of market forces or restrict or distort competition. The common law doctrine of restraint of trade and its relationship with Sherman's Act as well as with European Commission competition law has been explained by the courts at both the places respectively. Although in common law the courts have focused more on the effects of the restraint between the parties, while competition law focuses more on the effects on the market. The public interest, however, remains a touchstone in both the legislations to determine restraint of trade in both the jurisdictions, as we are going to talk about in this module, the United States and European Union. Usually, similar terminologies have been adopted. First, we are going to discuss the position as it exists in United States. In the United States, parallel federal as well as state antitrust legislations exist. The United States competition law is very easy but hard at the same time. Statutory principles are simple to say so but challenging, while applying to complex set of facts. Following legislations, as we are going to talk about now, are applicable to vertical restraints, as I introduced earlier. Sherman Act 1890, Section 1 prohibits agreements that constitute restraint of trade if they are on balance anti-competitive. The agreement can also be challenged under Section 2 if the party allegedly indulging in anti-competitive practice has monopoly power and if the agreement helps obtain or maintain such monopoly power. Federal Trade Commission 1914, Section 5 of this particular act prohibits entities from engaging in unfair or deceptive acts or practices in interstate commerce. Clayton's Act 1914, under Section 3 of this Act, it is unlawful for any person to lease or make a sale of goods made so as to substantially lessen competition or tend to create a monopoly in any line of commerce. In Robinson-Patman Act 1936, this particular US federal law, it is an amendment to the Clayton's Antitrust Act, and it helps prohibit anti-competitive practices by producers, especially price discrimination. The federal courts, like European Commission, they apply market power screen in most respects. So this market power screen is important. In tune with European Commission's the guidelines, these courts do not make an inquiry into the competitive effects of a restraint unless a manufacturer has got economic power in a relevant market, be it at the manufacturing level or downstream at the distribution or even at dealer level. And now let us have a look at the position in European Union. European Economic Community EEC was established by Treaty of Rome in 1957. It has been called as EC since then. And in this EC, vertical agreements fall within Article 81, subsection 1 of this particular treaty. Article 81 prohibits agreements that have either as their object or as their effect the prevention, restriction or distortion of the competition in the market. Article 81 further identifies certain acts which it deems as restrictive of competition, which are directly or indirectly fix purchase or selling prices or any other trading conditions, limit or control production, markets, technical development or investment, share market or sources of supply, apply dissimilar conditions to equivalent transactions with other trading parties, thereby placing them at competitive disadvantage, make the conclusion of contracts subject to acceptance by the other party of supplementary obligations which by their nature or according to commercial usage have no connection with the subject of such contract. In discussing this position further, Article 81 subsection 2 provides that such agreements are void unless and until exemption is granted by the European Commission under Article 81 subsection 3. Further, this Article 81 subsection 3 exempts all agreements that contribute to improving the condition or distribution of goods or to promote technical or economical progress while allowing consumers a fair share of understanding and the resulting benefit. These exemptions for our understanding we can categorize: 1. Where the practice is beneficial to consumers, for example, by facilitating technological advances, what we may term as efficiencies, but does not restrict all competition in the area. Second, agreements of minor importance except those fixing sale prices, wherein small companies together holding no more than 15% each in the case of vertical agreements, what we term as the de minimis condition, they are exempted. And block exemptions that include a list of permitted contract terms and a list of those banned in these exemptions, the hardcore restrictions. Further, other than this EC treaty, there are guidelines on vertical restraints. These guidelines set out the principles for the assessment of vertical restraints under Article 101 of the Treaty on the Functioning of the European Union, which we may term as TFEU. Article 101 subsection 1 of TFEU prohibits agreements that may affect trade between European Union countries and which prevent, restrict or distort competition. Agreements which create sufficient benefits to outweigh the anti-competitive effects are exempted from this prohibition under Article 101 subsection 3 of this particular treaty. By issuing these guidelines, the Commission aims to help companies to make their own assessment of vertical agreements under the European Union competition rules. Let us see how this law evolved in United States. In the United States, vertical agreements fall within Section 1 of the Sherman's Act, which prohibits generally any agreement that is in restraint of trade. In business electronics versus Sharp Electronics, this has been the one of the exemplary cases, where the court explained the meaning of the term restraint of trade. The term restraint of trade refers not to a particular list of agreements, but to a particular economic consequence which may be produced by quite different sorts of agreements in varying terms and circumstances. The changing content of the term restraint of trade was well recognized at the time that Sherman's Act was enacted. Earlier, the United States Supreme Court applied this per se rule to such agreements. And it was in 1970s when GTE Sylvania, the very famous case, placed non-price vertical restraints under rule of reason. Here we can refer to Khan judgment also, and this Khan judgment did the same to maximum resale price maintenance agreements in 1997. While in 2007, the Legion case followed the suit for minimum resale price maintenance agreement, and there US changed its stand on resale price maintenance by striking down, you have to note down here, by striking down 96-year-old rule that RPM were automatic violations of Sherman's Act. But despite Legion holding rule of reason treatment for minimum resale price maintenance has not been universally embraced. The California Attorney General has repudiated Legion and has insisted that minimum resale price maintenance remains per se illegal under the state's antitrust statute, the Cartwright Act. Maryland amended its antitrust statute in April 2009 to continue per se illegal treatment for minimum resale price maintenance. While if you can see that in United States, different states, they have different provisions, and then the New York Attorney General has taken the position that New York's antitrust statute, the Donnelly Act, makes minimum RPM, that is resale price maintenance, per se illegal. But courts have so far rejected the argument. Now, the courts have frequently refused to apply the per se rule and have declared rule of reason analysis to be applicable. In United States versus Microsoft Corporation, the court held that the per se rule was poorly designed to address newly integrated products in the markets for innovative technology. Therefore, the court applied rule of reason. The position of tie-in cases have been explained by United States Supreme Court's, I quote, "The essential characteristics of an invalid tying arrangement lies in the seller's exploitation of its control over the tying product to force the buyer either did not want at all or might have preferred to purchase elsewhere on different terms. When such forcing is present, competition on the merits in the market for the tied terms is restrained and the Sherman's Act is violated." Unquote. The Supreme Court further explained that a tying arrangement could be considered to be illegal per se only when it is shown that the seller has sufficient market power in relation to the tying product. In Standard Oil Company's case, the United States Supreme Court held that the requirement in the agreement violated Section 3 of the Clayton's Act as it restricted access for its retailers of other channels of procuring petrol and petroleum products. Therefore, competition may be said to be foreclosed in a substantial share of the line of commerce. In Tampa Electric Company's case, the Supreme Court explained substantially in the following words, I quote, "To determine substantially in a given case, it is necessary to weigh the probable effects of the contract on the relevant area of effective competition, taking into account the relative strengths of the parties, the proportionate volume of commerce involved in relation to the total volume of commerce in the relevant market area, and the probable immediate and future effects with preemption of that share of the market might have an effective competition therein." Unquote. To refer to yet another case of the United States Supreme Court, in State Oil versus Khan, the United States Supreme Court overruled Albrecht and held that vertical maximum price fixing, like the majority of commercial arrangements subject to the antitrust laws, should be evaluated under the rule of reason, as in its view, rule of reason analysis will effectively identify those situations in which vertical maximum price fixing amounts to anti-competitive conduct. Now let us trace the evolution of law in European Union. In European Union, Article 81, clauses A to E set out some of the classes of restrictions to which the article is intended to apply. The article applies to both inter-brand as well as intra-brand competition. The Commission held in European Night Services case that in assessing an agreement under Article 81, subsection 1 of the treaty, following factors should be taken care of. 1. Actual conditions in which it functions, the product or services covered by the agreement, actual structure of the market concerned. From the outset here, the primary objective of European competition policy has been that of market unification, that is, creation of a single market. Vertical restraints may result in partition of market and exclude new entrants. Where vertical restraints obstruct such integration, we can take example by allocating particular national or regional markets and territories to particular distributors, they are prohibited. If we can see the key decision in Constant and Grudging delivered by European Court in 1966 remains the most important case to be considered under Article 81, and one case that demonstrates the application of most aspects of that article. The ECJ, while examining the collusive distribution agreement, concluded that Article 81 applied not only to horizontal agreements but to vertical agreements as well. The ECJ held that, I quote, although competition between producers is generally more noticeable than that between distributors of the same mark, it does not thereby follow that an agreement tending to restrict the latter kind of competition should escape the prohibition of Article 81, subsection 1, merely because it might increase the former, unquote. I here would like to take your attention to one more case. This is Metro SB Grass Market GmbH and Company KG versus Commission, and the court held, although price competition is so important that it can never be eliminated, it does not constitute the only effective form of competition, or that to which absolute priority must in all circumstances be accorded. Thus, the court and the commission both recognized that there could be situations in which some restriction on price competition would be acceptable only if that restriction fostered other types of competition. And after that, large demands for exemptions emerged on individual basis, as happens. In 1980s, the ECJ began issuing block exemption regulations to exempt a class of similar agreements where positive effects outweighed negative effects. In windsurfing case, we can say that the Commission and ECJ both found agreements in contravention of the prohibitions on anti-competitive agreements. And when we are talking about this evolution, let us have a look at the position in 1990. In 1990s, a process of reform was initiated that resulted in the adoption of Regulation 2790/1999. It was a general BER for vertical agreements which would prevent them from being prohibited under Article 81, subsection 1 if certain conditions were fulfilled. Article 4 of the regulation provides for black clauses or hardcore restrictions on competition. We can take example of price fixing, setting fixed or minimum prices, directly or indirectly creation of territorial restrictions, limiting on delivery to certain customers, or restrictions imposed on authorized dealers within selective distribution systems on selling to end users, etc. These are certain examples. Arrangements that provide for such restrictions, they are void in their entirety. The Commission's guidelines on vertical restraints deal with agency agreements at paras 12 to 21. Here, the determining factor in defining an agency agreement for the application of Article 101, subsection 1 is the financial or commercial risk borne by the agent in relation to the activities for which he has been appointed as an agent by the principal. Genuine agency agreements do not fall within Article 81, subsection 1. Genuinity of the agency agreement depends on the question of allocation of risk. And if we talk about a recent case, the Commission has adopted Regulation EU number 330/2010 that replaced Regulation 2790/1999. This BER also provides a safe harbor for most vertical agreements and renders by block exemption the prohibition of Article 101, subsection 1 TFEU inapplicable to vertical agreements that fulfill certain requirements. If we refer to another case, in Pierre Faber case, the Court of Justice of European Union adopted a strict approach towards internet sale of products through selective agreements. It was held that an absolute ban on internet sales to end users in the context of a selective distribution network constitutes a restriction of competition by object unless justified objectively. Very recently on 14 March 2013, the ECJ ruled in Alliance Hungaria case that to determine whether an agreement restricted competition by its object, regard must be had to the contents of its provisions, its objectives, and the economic and legal context of which it forms part, as well as nature of goods or services affected and the real conditions of the functioning and structure of the markets in competition in the question. Let us see the pro-competitiveness of these vertical restraints. More often than not, we have observed that vertical restraints, they may not harm competition in any manner whatsoever. On the other hand, they improve economic efficiency within a chain of production, of distribution in the following ways. These are the ways which I am going to discuss with you now. 1. By facilitating better coordination between the participating undertakings or enterprises. 2. By reducing transaction and distribution costs of the parties. 3. By optimizing sales and investment levels. 4. By allowing consumers a fair share of the benefit. The EC has granted a block exemption to certain vertical restraints. These are referred to as vertical agreements, provided they fulfill the conditions set out in the regulations. Moreover, the exemptions will be applicable only if such agreements fall within the scope of Article 81 subsection 1. Now, in this module, we will discuss the problems which the courts have faced while evaluating vertical agreements, because in theory and in practice there are certain differences which the judges have to overcome, and the courts face this problem. After adopting rule of reason to the cases of vertical agreements, the courts have to determine the effects of such agreements in every individual case, which is really a daunting task. Also, the burden of proof in the rule of reason approach is on the plaintiff to prove that the practices being challenged are prohibited by the law. Once it is proved facially that the agreement in question is anti-competitive, then the burden shifts on the other party, that is the defendant. Since every contract includes some sort of restraints of trade, it is challenging to establish that the intended results could not have been achieved by using restrictions that were far more pro-competitive. Now let us analyze what have we learned in this module. By the contents which we discussed just now, we have understood the legal framework about vertical agreements as it exists in the United States and European Union. We have tried to find the approaches of the courts towards such agreements with the help of landmark cases, and we have learnt about the recent developments on the issue. And we can summarize also in this module the legal framework on vertical restraints in both European Union and United States has been analyzed in detail. The relevant provisions of the Sherman's Act, Clayton's Act and Federal Trade Commissions Act in United States have been discussed. Article 81 of the treaty and the guidelines on vertical agreements under Article 101 subsection 1 of TFEU have been analyzed. We have analyzed the positive effects like promotion of non-price competition and improvement in quality of service. They have also been dealt with, and the adoption of rule of reason approach in place of rule per se is taken up in great detail with the help of the landmark cases. And also we have tracked the evolution of the regulatory provisions, and that too we have done with the help of case laws. Thank you.